So what we've seen now is that an employee may sue for failure to accommodate, a religious belief or practice. Now, accommodation is a concept that's unique to religious discrimination. This notion that an employer must accommodate religious practices, but must only accommodate them until the accommodation creates this undue hardship. So accommodation, a concept that is unique to religious discrimination. And the boundaries of undue hardship are difficult to determine. Now, what we've seen in recent years is a number of cases involving basically the same topics. One of those is work schedules and time off. Work schedules and time off often present religious discrimination issues. Remember, religious discrimination applies even if it's a brand new belief. If you hired an employee and your employee was required to work on Saturday afternoon, and you hired that employee solely to fill your Saturday afternoon slot, if the employee joins a new religion and comes to you and says, I cannot work on Saturday afternoons, you as an employer can't simply say, hey, I hired you to work on Saturday afternoons, therefore I'm going to fire you because you can't work that day. You may be able to terminate them, but you have to go through the interactive process first. You have to seek to accommodate that belief. And work schedules is a huge problem when it comes to religious discrimination. All right, let's start all over on that. All right, start over, fresh. Work schedules and time off. Work schedules and time off are one of those most frequently litigated religious discrimination issues. Remember, when it comes to religious discrimination, even if the religion is recently adopted, you must still, as an employer, accommodate it. If, in fact, your employee is you hired him to work on Saturday afternoon, and then at some point the employee says, I've joined a new religion, I can no longer work on Saturday afternoon, you can't simply terminate the employee because he can't work on Saturday afternoons. Instead, you have to go through this interactive process. If at the end of the interactive process you can't reach an accommodation, then you can terminate the employee. Work schedules is always a hard problem. I had a friend of mine who had a law practice or worked at a firm in San Antonio, and it was a small firm. It was actually the branch of a Houston office. There were only a few attorneys there in the office, and they had one legal assistant and then another receptionist working there. And they hired the legal assistant during the summertime, and she was doing fine. She worked well. She did good work. And things were going along great until winter time arrives, the fall arrives, and it starts to get dark very early. And so the employee, the legal assistant, goes to my friend and says, look, I am a Seventh-day Adventist, and that means that on Friday afternoons I cannot work after sundown, and in fact I have to leave work and drive home and be at home in time for sundown, so I'm going to have to start leaving at 4 o'clock on Friday afternoons. Well, if you know anything about a law practice, you know that Friday afternoon is a very busy time often, that you need to get things filed by Monday morning, which realistically means they have to be filed by Friday afternoon. And so my friend says, look, we hired you to do this job. We're a small firm. We can't go out and hire somebody else to come in and work just Friday afternoons. We don't have anybody else in the office who can do your job. We hired you for this job. If you can't do if you can't meet the schedule, then we need to find someone else. And she says, if you fire me, I will file a religious discrimination claim. And so they did terminate her. And she did file a claim, and they wound up having to pay, 5 figures to settle the claim, all because of this need to accommodate a work schedule, even though the need was not there at the time of the hire. Dress codes, dress and grooming rules have been a key point in these types of cases. There was a case from just a few years ago involving a Taco Bell employee, and a woman was hired to work at Taco Bell, and Taco Bell has a dress code for its employees where they're required to wear black pants with the Taco Bell top. And the new employee shows up for work today and on her first day, and she's wearing a long denim skirt instead of the required black pants. The employer says, look, you got to change. You got to wear the black pants. I don't mind you working here, but you can't wear a long denim skirt. And she says, this is my religion. My religion requires that I wear this skirt and not pants, that it's against my religion to wear pants. And the manager says, look, I appreciate that, but it's called a uniform for a reason. Everyone has to look the same, and therefore you are terminated. She never worked there. Nevertheless, she files a claim for religious discrimination and walks away with $50,000 for this claim because the law says you have to accommodate her beliefs, and allowing her to wear a skirt was not that big a deal. Therefore, you're required to accommodate it. You have to change your rules. If someone showed up wearing a skirt and they said, look, I just prefer working in a skirt. It gives me a lot of advantages. I've always worked in a skirt. It's never been a problem at any other employer. You don't have to accommodate that person. You do have to accommodate the person who's doing it for religious reasons. Finally, religious beliefs and job duties. Sometimes religious beliefs can conflict with job duties. There was a case involving a worker at a nursing home, and the worker, one of the residents at the nursing home, asked the manager on duty if she would provide someone to help say the rosary with her. She was Catholic and wanted to go through this process, and so one of the workers was assigned to go tend to this woman's desire to have someone there while she read the rosary. And the worker says, I'm not going to do that. That's sinful. I don't believe in the Catholic Church, and I don't believe in saying the rosary. Therefore, I'm not going to do it. Her manager says, look, that's your job, is to help our residents with their requests. Therefore, if you won't do that, you're terminated. She is terminated. Again, she files a lawsuit, and again, she succeeds. So the lesson being for you guys is that when it comes to religious requests, you must engage in this interactive process. You must seek an accommodation. When we talked about dress codes, when we were talking about sex, we said employers are given a lot of leeway in setting different standards for men and women. That leeway doesn't apply to cases of religious discrimination. Finally, an employer may be liable for religious harassment. Again, harassment on the basis of religion is illegal under Title VII, just as any other form of harassment. And in these harassment cases that we've seen, it's often non-religious employees who allege that they're being harassed by religious employees. And so the question comes up is how much religious practice is acceptable in the workplace? How much can you, as an employer, constrain the religious practices of your religious employees to respect the beliefs of your non-religious employees? It's a difficult case because we've already permitted this the idea, the objective that we are going to promote religion, and how much of that do we have to accommodate? How much promotion of religion do we have to accommodate before it becomes burdensome on our non-religious employees? In this case, Peterson versus Hewlett-Packard company involved a worker in California, again, Ninth Circuit case, a worker for Hewlett-Packard. Hewlett-Packard had decorated the office with diversity posters, establishing that they were diverse and they believed in diversity, including sexual orientation diversity. And Mr. Peterson started posting on the outside of his cubicle religious passages, Bible passages, criticizing homosexuality, and would print these in large letters and put them on the outside of his cubicle. When Hewlett-Packard said to remove them, he said, again, this is my religious belief. You cannot take action against me for religious belief. Well, in this case, because of the harassment aspect, the court ruled in favor of Hewlett-Packard in that non-religious employees were being harassed on the basis of their failure to believe in the same religion as Mr. Peterson. So in conclusion, what did we learn? Title VII bans discrimination on the basis of religion. Identification of sincerely held beliefs can be problematic. And finally, proving a case of religious discrimination is different because of this duty to accommodate. That's it. Thanks for listening.